my pleasure now to introduce a gentleman who is no stranger to many of you. Jonathan T. Howe is the president and senior partner of Howe and Hutton, a law firm with offices in Chicago and Washington, D.C. He has written hundreds of articles, papers, and books, and has spoken to organizations all over the world on all manner of legal matters. He received his Bachelor's of Arts degree, majoring in diplomatic history and international political science with honors from Northwestern University, and his Juris Doctorate with highest distinction from Duke University, where he was first in his graduating class. He is one of few lawyers in the country who has argued before the United States Supreme Court. He's here today to talk with you all and share some knowledge about contracts, and we are glad to have him. Come on up.
Good morning, everyone, as I stumble on stage. I had the misfortune of sneezing about 4 weeks ago, which led to a rather interesting thing called a vertebral compression fracture. It sounds worse than it really is, but it's one of those things that I look at as being a big inconvenience more than anything else. So, pardon me if I do sit down from time to time, but I am a lawyer, and those of you who have heard me before, now, I always like to remind you that I am a lawyer, and that I know that none of you in this audience have a legal issue. You may have a friend who has a legal issue or two, and so any questions you ask or comments you make we know are for and on behalf of your friend who unfortunately cannot be here today. So we'll sort of take it from there and see how we play it down here. Contracts go on and on. We were talking last night with a couple people about, gee, you know, they've gotten so big, they're so ponderous. Used to be in the old days we could do it on the back of a cocktail napkin. Made that comment one time after the session. Person came up and said, John, the reason we did it on the back of a cocktail napkin was if we hadn't written it down, after 4 martinis we would never have remembered what the deal was. He said, but the problem was those bloody martini glasses, they would sweat and the ink would get all blurred, so we'd all have to start all over again the next day. Well, the reason I think that contracts have taken on such large dimensions today is relatively simple. Contracts today are based upon bad experiences. If you have a bad experience, you don't want it ever to happen to you again. You are going to put something in that contract that's going to address that bad experience, and you are going to make sure, even though it may have no applicability whatsoever to the program that you're about to do, I'm going to put that in the contract anyway. Just check myself in case there are a volcano in Iceland which impacts my meeting in South Carolina. I just want to be prepared overall to have that assurance. Well, we're not going to talk about some of the big things that happen in contracts. We're going to talk about some of the things that are in contracts that we overlook. Things that can have great importance after the fact, or as you go through the process of developing your meeting, your event, your incentive, whatever it might be. The key element we have to remember too is that my simple definition of a contract is it's a self-inflicted wound. But for the existence of the contract, there are no rights, there are no responsibilities. You are totally at the mercy of what you put on paper in that contract. Yes, we can have oral contracts. They are enforceable in most states, but there are limitations. One of the biggest problems with an oral contract is your memory may be a bit different than the memory of the person on the other side as to what was agreed to. So we like to make sure we put it on paper, that we have it in a format that people can read it, and more importantly, they can understand it. Contract drafting today, what we see so often, are really crummy. They have words in them that people, when you ask them, what did you mean by this? They'll look at you and say, I don't know, but you're the very first person who ever asked me about it. That should be a red flag. That should be one of those things that you really want to boil down and see what exactly the purpose and what the meaning of that is going to be. We don't want to keep saying, oops, as we go through the contract process. We want to be on top of it. Now, we all use and hear the term boilerplate. Well, boilerplate from a lawyer's standpoint is all that stuff we put at the back of the contract, which by the time you get to page 37, you don't have any more interest in reading it. You just take a quick look at it, pass it by, put your signature at the end of the deal, and send it back to the other party. But that boilerplate can have very significant meaning and impact upon the outcome of your negotiations, and more importantly, if you have the misfortune of going into a claim or litigation or arbitration relative to enforcing that agreement or having that agreement enforced against you. So we should pay attention to all the words in the contract. I mean, this business is, every time I turn around, there's a buzzword. My favorite buzzwords, rack rate. What is rack rate? I've gotten a lot of definitions, but my favorite so far is they've got you stretched out like this and you say, okay, I'll pay. But we need to know and have an understanding of those words. Another one of my little favorites are, English is a wonderful language. Problem with English is the same word can have two entirely opposite definitions. You want to have fun some night, you go into a 4-star, 5-star restaurant. After the maitre d' condescendingly says to you, good evening, what are the next words out of his mouth? Do you have reservations? Now, I'll look him straight in the eye and say, yes, sir, I do. But I'm going to eat here anyway. Same word, entirely different connotation as to what that word means. And that's what gets us into trouble in contracts so often and why we have problems. Now, what's the very first sentence in any contract? This agreement is entered into by and between X and Y, or between your organization and the hotel. But really, who are we negotiating with? Who are we really going to look to for purposes of enforcement of that agreement? It may say Embassy Suites on the outside, or Hilton, or Hyatt, or Marriott on the outside, but are you really dealing with any one of those brands for purposes of enforcement of that contract? No, you're not. You're dealing with the owner. And most of your major brands don't own hotels anymore. They got out of the hotel ownership business. They now manage hotels. And as the manager, they are given the authority to enter into contracts on behalf of the owner. So you want to make sure you know who exactly it is that you're doing business with. Hotels can be owned by individuals, they can be owned by partnerships, they can be owned by pension plans, they can be owned by governmental bodies. There's a whole group of people who like to own hotels or see that there is some future or some possibility of a return on their investment by virtue of ownership. So what we want to look at, that first line is, who is it we are dealing with, and have that identified up front before we get any further in the agreement. And sometimes you might find that the salesperson you're working with doesn't have a clue who the real owner of the hotel is. Generally, however, you will find that if they looked at their paycheck, they'll notice that the payee or payor is not Marriott or Hilton or whomever. It's going to be whoever owns the hotel. Once in a while, yes, sure, it'll have the brand name as being the issuer of the check, but that's part of their management agreement that goes on and on and on as to what they can do and cannot do. Another thing that is troubling to me is that the process, I mentioned the old contract on the back of a cocktail napkin, but today another question we have is, who are you dealing with and what authority do they have? Used to be you dealt with a sales manager, director of sales, you would ink the contract, deal was made. The salesman had to sell you then had to sell your company or your boss or your association on why this was a good deal. But now we have a whole different layer of how authority is divvied up in the operation of a hotel, or for that matter, an association or a corporation. What we look at today in the hotel, we have the sales staff, that management company whose name is on the roof, or maybe not. The management company may be somebody else, like with the mention of SMG being the managers of the convention center in Florence. So what we look at is we now go through another process. That management company is under contract. They are generally going to be accountable to another group called the asset manager, which is an in-between agent for the owner of the property. So you have these additional layers, and then you have the king of all hotel contracts. They are the person they have locked in the basement, the green eye shade over their eyes, and they're chained to their desk, and they are called revenue managers. They are there for one solid purpose, to maximize the amount of return on that piece of business. Now, if you're a corporate planner or association planner, you go through the same process. You have to now sell your boss on the business, who then in turn has to convince his or her boss, who then has to go down to the equivalent of the basement in the corporate structure and sell the director of procurement on how good a deal this is and that you've got it down to the lowest possible cost ever. Now, I have been thinking for several years that if I wanted to do a charitable event in this industry, I would have a caged fight. In corner A, I would have a revenue manager. In corner B, I would have a director of procurement. And the crowd would go wild, hoping they would kill each other off. And that phases some of the problems that we look at in the process today in contracts. And also because so many times now, what we hear is, I can't change that. That has been in our contract forever. We've got to have it demanded by the boss. I can't take it out. Well, you can negotiate anything, but you need to make sure you pick out what fights you want to take on. But let's go on and take a little bit further as to some of the basics that we have. Okay, there we go. I got a call from a client who says, John, we got an issue. We just got sued by the hotel for canceling. And I said, well, what else do you want to tell me? He said, well, we had cut a deal with the hotel after the fact that they would drop our room block by 50%. I said, that's pretty good, but I bet I know what your problem is. That they want 100% of the room block because you canceled, as opposed to 50%. He says, yeah, but we called them and we told them that we were going to be canceling out. We gave them 2 years' notice, and we had up to 365 days before the meeting to give them notice that we wanted out without liability. I said, open up your contract. Go to a page with a little heading that says notice on it. Yeah. What does that say? Any notice required or permitted under this agreement shall be in writing, sent by certified mail, return receipt requested. I said, now, you obviously did not send that letter, did you? No, but we talked to them. We sent them an email. What does the notice provision really say? They ended up it got negotiated down. But the point being, we have words in contracts that we think we know what they mean, or we think they're just inconsequential to what we might be doing. And so a notice clause is going to be one of those little clauses that you need to look at and remind yourself and the other people who are involved in the contract process that how notice has to be given. Otherwise, you might be on the short end of that stick, as was that client of ours who did not do it the correct way. Another little thing we find in contracts is what we call choice of law. What law is going to govern the interpretation of your contract? Now, you might be based in Chicago like I am, and you're doing business here in Huntsville. Whose law is going to apply, the law of Illinois or the law of Alabama? Well, you probably want it to be the law of Illinois, and obviously the property in Huntsville is going to want it to be the laws of Alabama. If you don't put in whose law is going to be used to interpret the contract, then the court now has to make a determination as to whose law should apply if there are differences in the outcome that could be impacted by the choice of law. and that will be determined by who has the most interest as a state or as a court to enforce that agreement. Well, performance is going to be here in Huntsville. The activities would all be in Huntsville. So the court is basically going to decide Alabama law is going to prevail unless you put something in the contrary in your contract overall. When you're going international, if you're going offshore, this can be a very important decision and topic for negotiation as to choice of law, because you may not want to have the laws of Italy applying to your agreement, or the laws in the Middle East, which is an entirely different beast. And in some countries, there are certain requirements as to how a contract has to be drafted and what you have to do with it in order to be able to make it enforceable against the other party. So there are little niceties like that. So we want to make sure that we've made a choice of law, we've put it in. Any of you have ever taken a cruise, and I'm sure, being the good people that you are, you have all read your cruise contract overall, just like you have read every word of your Facebook agreement that you clicked on when you signed up for Facebook. Has anybody done that? No. A lot of little interesting things in there if you take a hard look at it. But under most cruise ship, if you're going to have a lawsuit, it's going to be in Dade County, Florida. It's going to be in Miami. And the Supreme Court of the United States has upheld that requirement because of the interest of Florida in the cruise ship industry, and that there is a reason to use the courts and the laws of Florida for doing that. So we want to be very careful. Then the other little tricky thing is, okay, we've settled on the issue of the law that's going to apply. Well, where are we going to bring that lawsuit? Were we going to bring it in Alabama, or are we going to bring it in Illinois? Once again, you can put in the contract not only what law will apply, but where any lawsuit or arbitration is going to take place. So often overlooked, a very key element that you probably want to have the lawsuit if it's going to be brought in your town. The other side is going to want it to be brought in their town. If you don't put anything in as to where it's going to be, generally the courts will hold that the case will be heard where the incident or activity occurred. So once again, Huntsville would win out in that scenario of Illinois versus Alabama law, and it now also win out from the standpoint of the place or the venue where the lawsuit should be held. We'll talk a little bit more about implications of that in a moment. Alternative dispute resolution. When we have disputes, we have three ways by which we can get ourselves out of them: mediation, arbitration, litigation. I am not a great fan of arbitration, but the concept of arbitration is that it should be fast, it should be inexpensive, and it is final. Let me dissuade you for a second. It is not necessarily fast. It is not necessarily cheaper, and it's not necessarily going to end up with a decision that may only be challenged in court if there is fraud or the arbitrator acted outside the scope of the arbitration. Got done with an arbitration case about a month ago. The fees to the panel administering, along with the fees to the arbitrator, were in excess of $100,000. So it is not cheaper. You go to court, you pay your $75 or whatever it might be in your jurisdiction to file a lawsuit, and then you go forward from that. Arbitration, again, as I say, is final and binding. Once you have agreed to arbitration, you are stuck with it. And again, I'm sure that you have all read those arbitration clauses, which generally go along this way. In the case of any dispute arising out of this agreement, it shall be settled in accordance with the commercial rules of arbitration of the American Arbitration Association. Now, you all know what those commercial rules are, just like you know your Facebook contract. And the problem here is that those rules don't really help you a whole lot in determining how you're going to pick the arbitrators, or whether you have to use arbitrators from the American Arbitration Association. So if you're going to do arbitration, there's a lot more that needs to be put into that agreement for purposes of making it enforceable and understandable at the get-go. Now, what I love is when we have mediation. Mediation is somewhat of shuttle diplomacy. The parties agree to bring in an impartial person to serve as the mediator. The mediator's job is to go back and forth between the parties to see if there's room to settle, and if so, to put together a settlement agreement that would end the dispute at that point. If you have a good mediator, it's a worthwhile investment because you also will get a sense of what the other side's case is a little bit about, where the weakness might be in your case overall, and also glean some intelligence as to what the real issue is between the parties. So often we make an assumption that we know what the outcome's going to be. One case I use in my negotiation course is about the two girls sitting at the dining room table. And in the middle of the table is this great big orange. The one daughter reaches across to grab the orange. The second daughter slaps her hand. Mom walks into the dining room, sees what's going on. They both say they want the orange. So what does Mom do to settle the dispute? Cut it in half? Mom failed to do a very fundamental thing. She didn't ask them why they wanted the orange. And let's suppose, for the sake of this argument, that one of the daughters wanted it to make marmalade. And the other one wanted to make orange juice. She could have made 100% satisfaction if she divvied up the peel from the core of the apple. We so many times get into a dispute and we fail to find out why we're at that point. So we need to ask questions. We need to get involved in this. And that's what a mediator can help you do, is find out what the real issues are. Now, to the extent that we have mediation, everything that you tell the mediator, he cannot tell or she cannot tell anyone else. It remains secret unless you give them permission to share that information with the other side. Litigation. Well, I started out as a trial lawyer. I like still going to court. It's fun for me, not fun for the client. Both arbitration and litigation are draining both financially and from the standpoint of sleep and taking you away from other tasks which you should be doing but can't because of the litigation or arbitration. If we are going to court, we will have at least 3 bites at the apple. The trial level, the appellate level, the Supreme Court level. Maybe 4 if we get to the U.S. Supreme Court, but highly unlikely. The key here is that unlike arbitration, a wrong decision or an error in how the case is presented or allowed to go forward may allow you to have that second bite at the apple to come back and have a new trial. Well, by 97 to 98% of all lawsuits or arbitration demands get settled before they end up before a jury or a judge or an arbitration panel. Sometimes it may take several weeks. It took, in one case I was involved with not too long ago, it took us 4.5 months of trial before we finally were able to reach a settlement and get the case concluded. But it is, again, draining on your time, draining on your assets. It takes away from your other activities that should be more productive than having to go to court. Now, another little clause that works back in there in the boilerplate is what we call prevailing party. And a prevailing party clause is the first clause I look for in any any claim, arbitration, or lawsuit that's about to be filed or has been filed. And why do I do that? Because the prevailing party clause basically says, if you lose, you're not only going to pay your own lawyer's fees, you're going to pay their lawyer fees as well. I'll show you how outrageous this can become. Not too long ago, in a case for $18,000, a guy was hell not going to face up to it. He was going to use every possible ounce in his body to fight this lawsuit. And the legal fees kept going up and up and up. Finally went to trial. Jury came back with an award of $18,000 plus interest compounded at 1.5% per month, and then, for good measure, tacked on to the case approximately $110,000 worth of legal fees. So a case for $18,000 now is a $150,000 event. So prevailing party is also, in some respects, an invitation to file a lawsuit. You may not file it if you have a small claim. Is it really worth to go after somebody for that small claim? Maybe it is, maybe it isn't. But if there's a prevailing party clause in the contract, why not? You got nothing to lose, except unless you do lose. But if you feel pretty strong about your case and it's a slam dunk, if you got a prevailing party clause in there, you're going to encourage litigation or encourage arbitration to go forward. Another issue that we see so often is who has the right to sign a contract? I like to go as high up in the organization as possible to get a signature on paper. That means maybe if it's an association, the president of the association; if it's a corporation, some C-level executive to sign it. On the hotel side, I love it when the GM signs along with the director of sales. And we all know on the hotel side who the softest touch in a hotel is. The general manager. What do you mean you're $5 apart? Let's make this deal happen. So you might want to meet with the GM in those types of situations. But with prevailing party and authority to sign clauses in your contracts, don't set yourself up for a problem. Find out in advance and make sure that that person does have the authority to sign and that there is a representation of such. Then we have what I call the wrap clause, or a little clause that basically says what's in this document is what the deal was and is. And anything that either party said to each other before this document was signed is not part of the contract. So you can't say, oh, well, I assumed that we were going to do this, or I assumed we were going to do that. I thought that was part of the deal we made. And the judge is going to say, read this clause, even though it was orally made, and you may have relied on it to your detriment. The clause basically and clearly says that unless it's in the contract, all other bets are off. Which leads me then to another pet peeve, the use of amendments or riders to contracts. You get the call, I get the call, person calls and says, you know, we just attached a rider here, and again, this is a case where they had reduced the amount of attrition. They went forward and they looked at it and they said, oh, this is fine. Problem was that and they thought other items of the contract had been changed that you would reduce down for your complementaries, and everything else would be impacted by the reduction in the room block for attrition. It wasn't, because every rider, every amendment to a contract will start out with these words: except as otherwise stated in this amendment or this rider, all of the terms and conditions of the original contract dated such and such shall remain in full force and effect. And so what the rider does, it sets up a ripple effect. You need to read through your entire contract to see what that one little simple change may do to impact upon other things that you really and sorely want to have performed in going forward. There's a clause also which sometimes says, because the law will say generally we will use, if there's ambiguous words in a contract, we will convey or determine or define those words against the party who drafted the contract. So many times we'll see a clause in a contract that says neither party will rely upon the fact that the other party may have drafted the agreement for ambiguity, and rather it will become a question of fact for the trier of fact to determine. In other words, we're trying to get away from the rule that says if you wrote the contract, you own every single word in it, even though you've negotiated and bantered back and forth with the other side for its interpretation. Another dangerous clause that we are seeing, and you may see it too, it's use of data. It's a small little paragraph. Basically it says the hotel, or for that matter, the organization, reserves the right to utilize all data it obtains as a result of this agreement for any purpose that they deem appropriate. In other words, you've given away somebody else's privacy rights for purposes of that clause. But the hotels and others have gone further, and they put another word in there, that you have the obligation to get that permission from the attendee or from the hotel for purposes of being able to use that information, which is provided by the person who is coming to the meeting or is responsible for running the meeting. Signature lines. We look at contracts and they always have a signature line. How that contract is signed may personally impact upon you. If you're a third party and you're signing contracts for your client, or you're a planner or an organizer for and on behalf of a group, or you're a hotel salesperson, do you have the authority to sign? And by virtue of signing, do you make it clear that you are signing not as an individual, you're signing for and on behalf of the organization that you represent? And that becomes a real key. And we've seen cases where the courts will look at the signature, and if there's nothing in there, they will impose the liability on the person signing. One of the most egregious cases was a guy who was the treasurer of a small company who signed a check for $75,000 payable to the Internal Revenue Service. The company went out of business and went bankrupt. Who did the IRS sue? Our poor little treasurer for $75,000, because he did not indicate that he was signing the check on behalf of the corporation. And the IRS, being the wonderful, warm-hearted people that they are, said, "That's tough, buddy, $75K, please," and go forward from that. And so those are some of those little things we overlook. Your turn. We got a couple minutes left, don't we, Matt? Any questions on this? You notice I avoided the attrition and cancellation words. Haven't we beat that horse to death? But if you have a question, I'll be happy to try to answer it. Remember, this is free legal advice, worth what you're paying for it. Going once, going twice. Thank you all very much.